just repeat the question.
So the question was really, if you have an H1, and let's say the H1, something goes wrong with the H1, you don't have H1 anymore. The first question seemed like, do you have to be physically in the U.S. for this to continue? No. Where you are is actually not relevant at all. Actually, we have a ton of investors who are outside the U.S. and waiting for this to come through. So you can either be in the United States. It's a procedural difference and not a regulatory one. So if you're in the U.S., we file with the U.S. Immigration Service to get your green card. If you're abroad, we go to the U.S. consulate. That's really the practical difference. It's really not a legal difference. And the other question was about whether you can have both running. And the answer is yes. You can have the H1, which is a dual intent visa and permanent residency going on at the same time, and it won't affect your H1B. A supplemental question is whether or not the EB5 filing gives you any benefit to remain in the U.S. if your H1 goes south and you no longer have H1B. It actually doesn't. You need a non-immigrant visa to be in the United States. This one, until you get your green card, it really doesn't give you a basis. So while you're going through the I526, there's really nothing for you to use to stay in the U.S.